Here are 4 things that your trust attorney doesn't want you to know about your trust. My name is Gene Boykin. I'm America's top trust specialist, and I'm going to talk about something that nobody wants to admit. Just because an attorney drafted your trust doesn't mean you're protected. Here are the 4 clauses that your trust must have for you to be protected. Clause number 1 is a spendthrift provision. Spendthrift provisions protect against lawsuits, divorce, and creditors. Here's the problem. Most attorneys just throw this clause in as a boilerplate and then just call it a day. They don't structure it for real asset protection. There's a difference between having a clause and then having a clause that works. Clause number 2 is one of the most important clauses that I have seen, when they're not effective, wipe out people's entire estates, 6 and 7 figures. It's called a no contest provision. This clause stops unruly family members from turning your estate into a war zone. Without this clause, any family member can challenge your trust and drain it in court. And guess who wins when that happens? Attorneys and the courts. When this provision is properly structured, anybody that contests your trust is automatically disinherited, meaning they get nothing. This is what we call ultimate control. Clause number 3 is the discretionary distribution clause. This is where we see most trusts completely fall apart. Here's the thing. If your distributions are predictable, that means they're attachable. Creditors, ex-spouses, lawsuits can literally time your payouts and attach to them. But when you've structured it in a way where the payouts are fully discretionary yet structured, that's when you're playing a different ballgame. Most accountants don't even understand this, and most lawyers won't even explain it. Trust clause number 4 is the trustee removal and replacement clause. What if your trustee is completely trash? If you can't remove or replace them without court, you don't actually have control. I've seen so many trusts fail, not because of the person that is the beneficiary, but